Justice is not able to join us this morning. It's uncertain at this moment whether he will ultimately participate in this case or not. If he does, he will obviously read the briefs and listen to the oral argument on our FTR system before participating in the deliberation of the case. Having said that, we are going to have argument today, obviously, on this platform. I'd ask all participants to mute your microphones if you are not speaking. That will facilitate our hearing today. And I would just point out to council that the way we have been doing this is that the judges, if they have a question, will raise their virtual hand so that you will see that they have an intention of asking a question. I will acknowledge them when there's an appropriate break. So if you see a hand go up, find a natural break and finish your thought, and then allow the judge to ask his or her question. Okay. With that having been said, the first case on our docket today is Toro Credit Company versus Zeytoonijan, and I believe that there is a substituted defendant now. It's Mark Zeytoonijan as trustee, is that correct?
That is correct, Your Honor. Mark Zeytoonijan is the substitute trustee for the New Bar Realty Trust. Okay,
thank you very much, counsel. Please introduce yourself and let us know if you would like to reserve any time for rebuttal. Justice Doria is going to be keeping time and will raise a marker at the 5-minute mark, 3-minute mark, 1-minute mark, and then when your time is up. All right.
Thank you, Your Honor. William Fish for the appellants, and I would like to reserve 8 minutes for rebuttal, please.
Very good.
May I begin, Your Honor?
You may.
Thank you. The trial court here ordered a foreclosure by sale, and there are 2 large parcels of undeveloped industrial land in Enfield. In doing so, the trial court, we contend, made at least 3 errors of law. And as a result of these errors, the court abused its discretion when it did not order a strict foreclosure of just one of the 2 parcels. Parcel A, as the parties have been calling it. As found by the trial court, the appraisers for both parties valued parcel A at $950,000, and that was the larger of the 2 parcels. A strict foreclosure, therefore, of parcel A indisputably would have satisfied the debt in full. The debt, as found by the trial court, was slightly over $900,000, $902,000 to be more precise. But what I intend to do this morning is summarize very briefly these 3 errors, summarize the facts, and then go into each of the 3 issues in greater detail. The first error that we contend that the trial court made is that it expressly considered matters that necessarily would have developed post-foreclosure. And in doing so, the court concluded that the plaintiff here faced a risk of a shortfall.
Counsel, before you get too far into that part of the argument, I have a preliminary question for you. First of all, if the parcel A was $950,000, typically that would, and the debt was about $900,000, typically that would still be a foreclosure by sale because there was equity left in the $950,000, roughly $50,000 of equity. So why wouldn't that have been, even if your argument is correct, why wouldn't it have still been a sale of the parcel A rather than a strict foreclosure?
Because, Your Honor, when that happens, when a sale happens where the values are, as Your Honor posited, it's because either a subsequent encumbrancer or the owner is seeking to protect that equity. Here, that was not the case. Here, there is a blanket mortgage with more than one parcel. This is more like the Amresco case, where because there was more than one parcel, by foreclosing by sale parcel A, it unnecessarily exposed the owner here to a deficiency. As this court has recognized, I'm sorry, your hand looks like it may be going up, Your Honor.
Yeah, well, let me follow up on that. First, Oresco was an appellate court decision. Have we ever adopted the limited foreclosure doctrine that was articulated in Oresco?
Not precisely. I do not believe this court has addressed that question, Your Honor.
So it seems to me that when you have a blanket mortgage, the creditor here has a interest in both parcels, and I don't understand what could force them to forego part of their security interest if you don't know what the result would be at a sale. Just bear with me for 1 second, because if you have a parcel that is appraised at $950,000, that is obviously a well-educated guess about what the market would actually produce. But the plaintiff here shouldn't. Why should the plaintiff here have to forego the second parcel if the first parcel would not actually yield all of the proceeds necessary to satisfy the debt?
If you look at this first in the context of a strict foreclosure, Your Honor, there is no doubt that a strict foreclosure of a parcel worth $950,000 would fully satisfy the debt. So I start from that proposition. When that proposition, which I believe is indisputable, because when you do a strict foreclosure, the deficiency is determined not from a sale price, but from the fair market value. And this is an unusual case because normally you would have different opinions of fair market value. Here, that was not the case. They agreed to the dollar. So I start from that proposition, Your Honor. A strict foreclosure fully satisfies the debt. This court has held multiple times that in doing equity, a foreclosure court is supposed to consider not just the mortgagee, but the mortgagor and subsequent encumbrances. Here, we obviously do not have a subsequent encumbrancer, so it's mortgagor, mortgagee. In this context, by doing a foreclosure by sale, as this court and the appellate court have also recognized, it is far more likely that the sale price at the foreclosure sale will be less than the fair market value, because liquidation sales generally generate that. And so by doing a sale here, you exposed the defendant to a deficiency judgment potentially, while at the same time you did not, because strict foreclosure would have fully satisfied the debt, you did not expose the foreclosing plaintiff to a risk that it would not realize the value of what it was entitled to. And as this court has held, the foreclosing plaintiff, the mortgagee, is only entitled to the payment of its debt.
And my final question is, given the practicalities here that it was relatively close, within $50,000, and that judgment was 2 years ago, should we take into consideration that interest and attorney's fees have continued to accrue, and that the dynamic might be different regardless of what the outcome of this case is? It has to go back for new findings of debt and value, correct?
I disagree with that, Your Honors. I certainly understand that if the court rules in our favor and remands it to the trial court, this may be a do-over, for lack of a better word. Right? We're certainly well past the time where the appraisals would be current. And so you might get new appraisals, you might have new debt. My argument to this court is that if you reverse the trial court based on an abuse of discretion standard, which I believe exists here because of the errors of law, it should be remanded to the trial court with direction that it enter a judgment of strict foreclosure of parcel A. And that's because the only reason we are here is because Toro did not accept the strict foreclosure of parcel A, which again, indisputably would have paid it in full. And so we should not have to go through the do-over, if you will. If it does go back, I understand that is certainly one of the things that can happen. I would point out that although interest might accrue and fees might accrue, and we might argue against that, the values also might go up. In this case, the plaintiff's appraiser first appraised parcel A at $900,000, and then at trial came in at $950,000. So we actually had a small delta prior to the trial.
Thank you. Justice Khan is next.
Thank you, Justice McDonald. Attorney Fish, I have questions I think are similar to the concerns that Justice McDonald raised, but I'm sort of coming at it, I think, from a different angle. You argue that under 49-24, the plaintiffs here did not seek foreclosure by sale. They asked for strict foreclosure, and therefore they're limited to that relief. But I understood that when it came to foreclosures, there was a principle of law that a court, if there is any kind of equity in a piece of property that's being foreclosed on, that a foreclosure by sale is preferable because it protects the debtor. And so I guess in this case, it seems a little sort of backwards. Typically, it's the debtor asking for a foreclosure by sale in order to capture that equity that's left, the value that's left over and above the debt. And so I'm not sure if they are limited to only a strict foreclosure, if the court finds in its equitable power, its authority to render equitable rulings to order a foreclosure by sale. Can you elaborate on that?
2 points to that, Justice Kahn. First, if there is a simple situation where the value of the property, say, is $200,000 and the mortgage debt is $190,000, so the value of the property is slightly over the mortgage debt. If I'm counsel to the borrower, and again, no subsequent encumbrances, the risk of exposing that property to a foreclosure sale and a potential deficiency is significant. It is recognized by this court, and it's the practice throughout the state, that foreclosure sales, liquidation type sales, often result in less than fair market value. The appellate court has approved sales that are 40% of fair market value. So it is highly probable in the real world that, in my simple example with a little bit of equity, that the sale would come in below the debt. And automatically then that results, I'm sorry, I think Your Honor was speaking. I apologize.
No, please finish. I thought you were finished and I was going to ask a follow-up. Please finish that thought. And
automatically in that circumstance, because now the deficiency is determined based on the sale price, not the appraisal price, there would be a deficiency. So the premise of Your Honor's question, to get to the point here, is that it is often not the case that an owner-debtor would often not choose to go through the sale process for the same reason we're choosing not to do it here. It would expose us to a deficiency. A strict foreclosure eliminates that risk. Many times in the real world, again, we have a disagreement on the appraisal price. And so it becomes a more complicated question because now I've got to take into account the mortgagee's appraisal. We don't have that issue here.
So here's my sort of follow-up question to that. And I have two, I think they're rather quick questions because I notice my colleagues have their hands up. So as a follow-up to that answer, I always thought that even in strict foreclosure, that the plaintiff could always come back and seek a deficiency judgment over and above what, if there are costs that were not covered, they could come back and seek additional funds. So that's question one. And in this case, is your concern or your claim remedied by the fact that the trial court said at Exhibit A-19 that your client would be given options, meaning the second sale, the sale of the second parcel, would not happen unless there was a deficiency and the debt could not be met or satisfied with the first sale. So my first question is, wouldn't they always be able to come back and get additional money to cover deficiencies? And two, doesn't the trial court's offer of an option, in essence, alleviate your concern?
The answer to the first question is no, Your Honor. When you look at the fully laden debt, in other words, let's put all the fees on, all the interest, everything else that the mortgagee is entitled to. If that amount is less than the appraised value in a strict foreclosure, there is no deficiency. The law is clear there. This court has made that very clear. That is full satisfaction of the debt. Other obligors, guarantors, secondary obligors, none of those people are exposed to a deficiency. There's a technical issue about could you come back with a different appraisal number at a deficiency hearing, but in this case, given the evidence and given the timing, that's just not the case. Your second question, I forget how it's phrased, so I'm not sure if yes or no is the right answer. But it did not. I'm sorry.
Given that your client is given an option, the second sale wouldn't occur unless there's a deficiency. Doesn't that solve the concern?
It does not, Your Honor. It does not, because let me give a simple example here. We know, because this court and the appellate court has said it, that foreclosure sales frequently come in less than the debt. So let me give a simple numeric example. Let's assume that the plaintiff in this case is the only one showing up at the sale, which is often the case. This is industrial land. Credit bids 50% of the debt. I'm sorry, 50% of the value, of parcel A. Right? That'd be $475,000. That's the high bid. It does the same thing on parcel B, $425,000. That's the high bid, 50% of the appraised value. This court, the appellate court has approved sales at that level, absent some unusual event regarding the sale. So under that scenario, the plaintiff comes in, credit bids half of the value for parcel A, half of the value for parcel B. When the dust settles, they have parcel A, they have parcel B, and they have a deficiency claim. Because they move for a sale, there's a credit under the statutes for that, but that doesn't affect my argument.
But doesn't that happen when the actual value of the property is less than the debt? This doesn't seem to be the case here. But I understand, conceptually your argument, and I don't want to take up more time because I noticed two colleagues have their hands up. So if you want to comment on that, and then I'm going to yield back to Justice McDonald to call on the next justice.
One quick comment, if I may.
Yeah.
If you look at what we had proposed, I'll call that scenario one. Strict foreclosure, parcel A, the plaintiff is indisputably satisfied in full under our law. That's scenario one. So plaintiff walks away with parcel A, we retain as the debtor parcel B, and we have no deficiency. If you go to my example that I just gave, where there's a foreclosure by sale, where the plaintiff bids a price that the appellate court has approved in the past as being a fair price. When the dust settles, plaintiff walks away with parcel A, plaintiff walks away with parcel B, and there's a deficiency. This court has made it very clear that in exercising its discretion, a trial court is supposed to protect not just the mortgagee, but the owner. And in my simple example, which is very, very likely and common, that did not happen because a foreclosure by strict foreclosure of parcel A would have given the plaintiff everything they were legally entitled to. Full satisfaction of the debt under our law.
Justice Ecker.
Good morning, Mr. Fish. So I have two questions. One is on the basic argument. I mean, I totally get what you're saying. We'll hear what Mr. Babin has to say in response, but your point has the virtue of simplicity and maybe it's right under foreclosure law. The property's valued at $950,000. If the court finds that value to be $950,000, that's what it's worth. And you don't worry about, you do a strict foreclosure and you don't worry about what it could be, quote, really worth. That's what you worry about in sale foreclosure. So I get that, and I look forward to hearing Mr. Babin's response. But what about the contractual provision? Does that change anything? Because Mr. Babin says it does, and the trial court said it sort of does. What's your response?
Yeah, my response to that, Your Honor, is first let's look at Article 9. Because Article 9 has been recognized as important here.
Is that the contract or the UCC?
UCC Article 9. I'm sorry, UCC Article 9. Because UCC Article 9 makes a very clear distinction about how creditors, secured creditors, can select a remedy. Let me just read comment 2 from Article 9, 602, because it answers this question, then I'll elaborate. It says, with exceptions relating to good faith, diligence, reasonableness, and care, immediate parties as to themselves may vary provisions in an agreement. However, here's the point. However, in the context of rights and duties after default, our legal system traditionally has looked with suspicion on agreements that limit the debtor's rights and free the secured party of its duties. As stated in former section 9501, comment 4, no mortgage clause has ever been allowed to clog the equity of redemption. The context of default offers great opportunity for overreaching. The suspicious attitudes of the courts have been grounded in common sense. This section, like former section 95013, codifies this longstanding and deep-rooted attitude. Article 9, if you're going to do a strict foreclosure of personalty, you require under 9620 post-default consent, and that cannot be varied by agreement. And the reason you do that is because if we allowed the remedies section in the mortgage to control here, think about the things that could happen. First of all, I can pretty much assure this court that there would be many, many smart lawyers writing very detailed remedy sections in mortgages throughout the state, all of it in an attempt to tilt the scales in terms of how a court is supposed to exercise its discretion on this one issue, which is, should this be a strict foreclosure or should this be a foreclosure by sale? And inherently, that is an economic question. As this court has recognized, what we're talking about there is, what's the value of the property? What's the value of the amount of the debt? Is there a deficiency? Those are all economic considerations.
So I mean, one other way of putting the point, I guess, is that considerations of public policy and as embedded in our statutory scheme doesn't allow for contractual provisions to change the legal arrangement in terms of a remedy. At least I sort of take that to be what you're saying.
Yes.
The second question is this. So just looking at the numbers in the per diem and so forth, we've probably got another $110,000 or so in interest over the last 2 years. And I don't know what Mr. Babin's attorney's fees are. But let's say, just for the sake of argument, that it's another $100,000. So we've got a couple $100,000, and I'm not making any forecast in that regard, or giving it, I could be anything. I'm just throwing a number out there. So we've got $200,000, let's say, of additional. We're over the 950. You win. This is all hypothetical. The case goes back, and the parcel A isn't enough to satisfy the debt. So you're actually in, theoretically, now we need a sale, at least of the second, property, and you've gained nothing and maybe lost something, a couple $100,000 by this exercise. So my question is there any, in divorce cases, there's Sunbury against Sunbury, and there's cases where say you go back to the original date of judgment. I'm not sure that applies here, or would, but I'm not sure that's before the court. Maybe that's the next case. I don't want to waste your time if it is. I've already done that enough. But could you just comment briefly on that? If it's the next case, tell me. If that's fine.
First of all, we also don't know, if we went back and did all those additions, what the property was worth, because the property could go up in value too.
Fair enough.
Which could be more than everything else that Your Honor just posited. There are also precedent out there that if a defendant tells a plaintiff, we hereby stipulate to strict foreclosure, and the plaintiff doesn't take it, the entitlement to interest does not continue, because I'm offering as a defendant to say, take the collateral. So there are a lot of issues there. As I said to Justice McDonald's question, I think in this case, given in my mind the fact that the trial court clearly took into account post-foreclosure events, just focus on that for a second, insurance, taxes, what the property might sell for, marketing expenses, all these things.
All right, Mr. Fish, I don't want to cut you off, except for your time is low. I know Justice Doria has a question, and you've thoroughly answered my question, so thank you.
Thank you. I didn't realize the hand was up, Your Honor. I apologize.
Justice Doria.
Yeah, and your time is up, but I'm going to ask this question, and Justice McDonald can decide whether he wants to give Mr. Babin a little extra time. So I don't hear you making the argument, though, straight up that the provision in the contract that if we construe it to say that they bargained for foreclosure by sale, violates the public policy of the state. I understand you're saying that it's not fit, that's not the rule here in Connecticut, but usually we get an argument or, when you litigate and say it conflicts with the law, you'd say it's void because it violates public policy. You're not arguing that.
No, I am, and I thought I said that in response to Justice Ecker's questions, Your Honor.
That's what I want. I mean, I don't see that in your brief.
It may not have been in the brief that way, but it is our position. It was our position to the trial court that this result, in other words, the remedy election, which I also don't think that the plaintiff is reading it properly, but put that aside for the moment.
Yeah.
The remedy election in this mortgage, the selection of the remedy, gives the mortgagee too much power. It is against the public policy of the state of Connecticut. It impinges on the discretion of the trial court in answering the question about foreclosure by sale or strict foreclosure.
And what's the best case for that? Because usually you can bargain around. Statutes can be bargained around, in lots of contexts. And so, go ahead.
They can, Your Honor, but I have looked high and low. And there are no foreclosure-related cases in Connecticut that address this issue one way or the other. It's a blank slate, which is why in Mr. Babin's brief, he talks about contract issues generally. In my response to Justice Ecker, I made the point about Article 9, because by analogy, that very much applies here. Part 6 of Article 9 is all about enforcement of remedies. And it's a very detailed section. 9602 imposes detailed limits on the rights of parties not to vary by agreement all these provisions in order to protect people. That embodies the public policy of the state of Connecticut. And as Justice Peters said in New England Savings Bank v. Lopez, it is appropriate to look to Article 9 in order to inform real property law. So my argument here is the same. If you allow mortgagees to put into their mortgage issues that are controlling, just think what that would do to the trial court. If I had a simple case where the value of the property was $400,000 and the debt was $200,000, and the mortgage says, mortgagee, I have the right to a strict foreclosure. Is that controlling? I mean, we have $200,000 of equity in that property. The subsequent encumbrancer or the debt or the owner are asking for foreclosure by sale, to Justice Kahn's point, to protect themselves. It can't be the law that a mortgagee can override that discretion.
Okay, well, let's see what Mr. Babin says, and maybe we'll take this up in rebuttal.
Thank you.
Thank you. Justice Doria, how many minutes over was that? Okay, Attorney Babin, you have 32 minutes.
Thank you, Your Honor. Jeffrey Babin from Wigan and Dana for the plaintiff, Toro Credit Company. It is true that strict foreclosure would extinguish the equity of redemption, but it certainly would not make my client whole. There is no rule, as Mr. Fish seems to be contending, that the risk of sale, of a shortfall from the sale, is always borne by the lender. The case law is very clear that the trial court sits as a court of equity in foreclosure, has a wide range of discretion, and in fact, as was stated in the case of National City Mortgage versus Stoker, the decision of whether strict foreclosure or sale lies within the court's discretion. And this court also said the same thing in New England Savings Bank versus Lopez, even though in that case, the sale did result in a deficiency. There is no bright line that the defendant, as in this case, gets to choose whether it's a strict foreclosure or a foreclosure by sale based on what it perceives as most financially advantageous to itself. And there's
Mr. Babin, Attorney Babin, Justice Doria has a question.
Sure, certainly.
And forgive me, I guess both of you, if I'm missing too much nuance in all of these arguments, but I'm going to ask you sort of the flip side of the question I asked Attorney Fish. Is you seem to be arguing that it's appropriate, as I read your brief, that the trial court properly consider, I'm reading from it, the parties bargained for remedy of foreclosure by sale. Why aren't you arguing that it's just controlling? He doesn't have any discretion, because I'm asking him why he's not just arguing that it violates public policy, and I guess now he sort of is, but why isn't this just control?
Certainly, and the provision that the parties contractually agree to, and it has to, well, first let me remind the court that these were two sophisticated counsel parties negotiating a deal. This is not a residential foreclosure. Toro is the major New England distributor for turf products, and this note was one part of a series of 6 notes of a $14 million restructuring, which a complex structured transaction between sophisticated business entities, with Toro being controlled by the Zeytoonijan family, who pledged a variety of properties for 6 different notes and paid off most of those notes except for this one. That was part of a deal to strengthen the relationship between the two and keep the distributor strong. So yes, the parties in this context that the court can take into account, and it did so here by having a trial, which was not typical in a foreclosure context, but in this commercial context was perfectly appropriate, to understand the context of this, that the defendants were getting an advantage, keeping them in business for 15 years, which my client was unwilling, though, to take any risk at all.
Okay, so let me just interrupt you there, because I mean, the fact that you're not arguing that it's just governing, end of story, it's equitable, and maybe that's appropriate. I'm not trying to make your argument for you. Tells me that there are situations where you would say that a foreclosure by sale was not appropriate, even though you bargained for it, and the court shouldn't order it. What's an example of something like that, where you would say, yeah, we bargained for it, but you know, the court was right not to order it?
Mm-hmm. Well, you know, an example is not coming immediately to mind. What I do know is on this record, Judge Sicilian understood that Toro, which put a lot of money, Toro put a lot of money into the defendant's business, would end up risking not being made whole. Now, there may be other circumstances where that isn't the case, and there may be some perception of unfairness. I think this case really turns on the fact that there's wide discretion, and at the end of the day, nothing that the trial court did here was outside the bounds of any statute, or was outside the bounds of the document. Within the statute, which permits this kind of sale, and within the bounds of the documents, the court can take into account the variety of circumstances, particularly in this type of commercially complex deal, where the courts have said time and again, and we have some trial court decisions that are in our appendix, the Patelli case, the TD Bank case, when we have commercially sophisticated parties, the court can take all those circumstances into account, and that is what was done here. There may be other circumstances, I can't think of an example right now, but what the court did here, in fact, gave the defendants an unusual amount of control over trying to ensure that the interests are balanced. That was not in the contract either, and we agree that the court was allowed to take into account, but it's not necessarily controlling. And the court here, and we don't object to this, decided instead of just simply having a sale of both properties, gave the defendants a fair amount of control in this context to help maximize the sale value. So it took into account the defendants' concerns and allowed the defendants, who themselves had been trying to market this vacant, undeveloped land before the foreclosure and had been trying to market it as one contiguous parcel in an industrial area where there is demand for warehouses like Amazon warehouses, distribution centers, and asked the parties, which would have been done if this appeal hadn't been taken, would have been done by now, asked the parties to come up with a joint plan and gave them a considerable amount of discretion as to whether it's going to be one or the other parcel or both, as they had been trying to do themselves in advance. So we don't deny the discretion. In fact, it's Mr. Fish's client who's trying to deny the trial court the discretion. It's the defendant's position that the court can never take circumstances into account. The argument that Mr. Fish has made is that you can never look at the bargain for terms in a commercially sophisticated transaction that both sides settled on, that it's a mechanical exercise, that there's no room for judging, as Judge Zeytoonijan did here. Now, the leading Connecticut foreclosure treatise, Connecticut Foreclosures, which is cited in our brief, specifically says that in a context of contiguous parcels like this, there is discretion to sell together or separately. Judge Zeytoonijan took that page right out of that playbook. The Amresco case that Mr. Fish relies on is a case that neither side asked for a sale. So it's not this type of situation. It was where there were 5 parcels, non-contiguous, and I'll just finish this thought. I see there's some hands up. 5 parcels, non-contiguous, and the court ordered strict foreclosure of 2 of them, and the lender said, no, I'm entitled to strict foreclosure of all 5. The contract says 5 parcels, and the court says, well, we can modify that as a matter of equity so that there's not a windfall. And that's the court here. And here, of course, we avoided that by raising the sale option, and the court adopted that sale option. So Amresco talks about wide equitable discretion. That is true, but it's a different situation here, which we avoided, and Judge Zeytoonijan avoided through his equitable disposition of this case.
Thank you, Justice Ecker.
I think I have 2 questions. One is, you said it, I think, right at the outset. Good morning, by the way, Mr. Babin. You said that your client would not have been made whole by a strict foreclosure of the 900 partial A, and I don't understand that. I mean, Mr. Fish's argument is as a matter of law, if the property was valued, a fair market value of $950,000, that's not, you don't then say, well, maybe it would take them a while to market. You know, it's $950,000 they're getting for a $900,000 debt. So why isn't that being made whole and then some?
Well, it is true that if strict foreclosure were ordered and the appraisal is more than the debt, then that would extinguish the debt. But that's exactly what my client bargained not to have happen. And in this commercially sophisticated world of here, would never have put up this $14 million of structured debt on a variety of properties, including this one note, which was part of it, if they were going to have to not be made.
Well, we don't know that, Mr. Babin. We don't know what your client.
There's
we don't know what your
trial.
We don't know what your client would have done in terms of the $14 million loan without this contractual provision, do we?
Well, there's testimony, Your Honor, that this was an effort to strengthen the relationship between the two. This was not intended to be an oppressive situation. And there was testimony by the attorney who was involved with this, that you know, why they had, for example, with this note, they had 2 parcels to make sure, a blanket mortgage on 2
I understand.
to make sure that they would be made whole and that they would never, in risking this kind of money, and it was successful for 15 years. They would never.
Now,
have
Mr.
done
Babbitt,
so.
can I ask you a different question? I get it, and I'll look at the transcript. As I recall, there was some testimony that was allowed on the intention of the parties, and some that wasn't allowed.
It was circumstances that were allowed. It wasn't parole evidence.
Okay.
It was background.
Okay.
The
All right,
court-
I'll let that go.
Fine line.
Yeah, it is, especially if the contract is ambiguous. But the question about your second point, which is this: what do you do with Mr. Fish's example of the radical unfairness that could accrue to his client if this goes by sale? The credit example where your client ends up with both pieces of property and a deficiency judgment at the end of the day. Tell me why that is far-fetched or fanciful.
Well, first of all, it's actually speculative, Your Honor. I mean, this is a case where
No, Mr. Tell me why it's far-fetched or hypothetical. What do you say would have happened?
Let me see if I understand Your Honor's question. My understanding is on this record that was before the trial court were appraisals that essentially said that this property was worth, roughly $1.8 million. And remember, this was this was two parcels defined as the premises, and it was a single mortgage on both. The debt was under $1 million. And under
Mr. Babbitt, let me ask the question this way: Do you think that what Mr. Fish's speculation about what would have happened, what was a likely scenario, what was a reasonably likely scenario, right, where your client gets the properties at 50% credit and ends up with both properties and a deficiency judgment of $100,000, $200,000, maybe more? Why is that? Why is he wrong?
Well, first of all, this court said in New England Savings Bank v. Lopez that the court has discretion.
No, Mr. Babbitt, I'll give you one more chance.
Okay.
The hypothetical. You tell me what you think would have happened if the sale had gone through in terms of commercial likelihood and reasonableness. I mean, I'm not asking you to.
Sure, I can answer that question. Your Honor, a couple of things. First of all, the sale, if this court affirms, there's going to be a sale, and then the case comes back to the trial court, and the trial court has to confirm the sale. And that's very clear in the case we cite, Central Bank for Savings versus Hegeland, that the courts can then determine the appropriateness of the sale price. And if that was the case, they said, if we find that it's wholly inappropriate, we still even have the discretion to switch to strict foreclosure.
Mr. Babin, at least when I said foreclosure, the rule of thumb was 70%. Right. So Mr. Fish was using 50%. I guess an appellate court decision has affirmed 50%. But the trial judge typically would approve a sale at around 70%. It could even be a little less of the appraised value. So again, we've gone back and forth and
no, but I can say a few more things, Your Honor, which is that this is a case, of course, unlike in the typical foreclosure case Your Honor may have come across, that they know that this is a defendant who is sophisticated in real estate, who has been trying to market, and gave them a hand in this decision to try to maximize this. And this case will go back to the trial court, and if there's a sale, the trial court can determine whether the sale price is appropriate at the time of the confirmation and make adjustments if necessary. If it somehow things turn out to be the way that Mr. Fish thinks it could turn out to be. But that doesn't restrict the discretion of the trial court on this record to have done what it did at the time it did.
At that point, the fees will probably be equal to the value, and the interest will probably be equal to the value of both pieces of property, and you can do a strict foreclosure on them.
I don't think it's going to be that much, Your Honor. But Mr. Fish's client decided to take this appeal, and the trial court on remand can certainly take into account any changed circumstances because nothing is final. It's very clear in the case law. Nothing is final until there's proceeding on the confirmation of the sale. It is true, though, that until after the confirmation of the sale and then the changing of the deed under the one of the national mortgage cases that we cite, that that their debt does continue to run. But you know, this was a case where the courts can take into account the fact that there may be a shortfall from strict foreclosure, and could take into account the fact that that's something that Toro made very clear that it was not willing to do anything to enter into this kind of transaction without being made whole, to take into account the sophistication of the parties.
Counsel, let me ask you a question. The Oresco opinion from the appellate court was in 2001, I think. Has it been followed much in the trial court? I didn't get a chance to shepherdize it or see if it's been widely used. Do you know? I have not come across that. I don't have the sort of Shepherd's printout. I'm not aware of it being widely followed. And we don't dispute the outcome in that case, where neither side asked for a sale, and it was a question of whether you simply have strict foreclosure of 5 parcels or 2 when there's a blanket mortgage of 5. And let me ask you, I don't know if this is in the record or not, but you mentioned that these are 2 sophisticated commercial parties. They bargained for a blanket mortgage, right? Was there any indication of whether or not there had ever been an effort to have 2 separate mortgages, a first mortgage and a second mortgage, to secure the properties?
No, Your Honor. First of all, this was, and these are, in the record. There were 6 notes. Some of them were secured by things like the defendant's the Turf Products, which was owned by the Zeytoonijan family, that was secured by Turf Products headquarters building and other assets. This one was, this is the one note that they haven't paid off, was secured not by any building, not by anyone's house, not by anyone's store, but simply vacant, undeveloped land is the one they chose to stop paying on after Frederick Zeytoonijan, the founder, passed away and his children took over. So it was clear that this is highly structured, and they required, as we can see in the note and from the testimony, they required that there be 2 parcels on this that were contiguous parcels defined together as the premises, parcel A and parcel B. And that was a natural thing in this instance that was bargained for, because as we know from this record, that even the defendants have been trying to sell that property. They have no interest in holding on to this property. They've been trying to sell it themselves as a unified parcel for development in an industrial zone. So there's no indication as to that there were other efforts to have first mortgage or second mortgage. And the trial court here handled that in an appropriate way, just exactly as the Connecticut foreclosure treatises provide, and giving them, an unusual amount of control and discretion here as to how this is going to be marketed.
Well, on that point, I've just never heard of a trial court giving that authority or option to the litigants. I don't know. Maybe they can. I've just never heard of it. But I guess normally, to guard against what Attorney Fish has identified as a potential problem, the trial court, I guess, could have ordered a sale of the first parcel, and if that type of gamesmanship was being undertaken by your client, could either confirm that or not before making a determination about whether to proceed with a sale on the second parcel. Is that not correct?
But that's exactly what the trial court here did. And
well, but they gave it that option sort of to the parties, didn't it?
Yes, it allowed to maximize the value, and allowed the defendants here who have an intimate understanding of the market here to decide whether to market them together or to market one at a time, and to choose which one. So that was all to the defendant's benefit, which actually goes beyond the four corners of the document, but it shows the wide equitable discretion of the court to take into account the particular circumstances of this one case. It wouldn't necessarily apply to your average homeowner's residential foreclosure, where and even there. So, for example, Bank of America, expects that there is going to be lots of strict foreclosures. It's going to have to hold these it's going to end up taking ownership of these properties and having to turn them around. That's not what Toro wanted. That is
Thank
what
you.
Toro.
Justice Khan has a question.
Oh, certainly.
Thank you. Thank you, Justice McDonald. Attorney Babin, my question is, when I look at the trial court's opinion at A19 or page 11, the conclusion paragraph, where the court gives the defendants the option to sell, to either put both up for sale or sell one first to satisfy the debt. Is that a real option in a sense when you consider the trial court's finding at A11 of the appendix or page 3 that the court seemed to find, based on one of the experts, that together the property is worth 1.9 million. So if a defendant is faced with the option of either putting the properties up sequentially or one or together, why wouldn't they then be forced to put them up together? Is that a real choice when they can get more money, presumably, if they market them together as opposed to separately? So it's sort of the flip side of the question I asked your opponent. Is that a real option?
Yes, we believe it is, Your Honor, and it was within the court's wide discretion. So on this record, parcel A, as Mr. Fish has pointed out, was worth slightly more under the appraisal than what was the debt, total debt at the time. So if they wanted to take their chances and just have parcel A sold first, and it given the market for this type of land in the Enfield area, it pays off, and they have lots of contacts, the defendants in the area. They can interest people in this bid. It's not like your typical residential foreclosure. It may be enough, and then they can keep the second parcel and sell it however they want, or develop it themselves if they wanted at that point.
But when the party's experts affirmatively say, look, if you market them together, they're worth more, why would the defendants not want to maximize the value of the property, particularly when they have substantial equity in it?
Sure.
It could be sold for its value marketed together. I understand your point, but then that places the risk entirely on them. And it doesn't seem to make sense that they would then, seek to sell only one if they could get more money selling them together.
Well,
they're walking away potentially from.
Sure. Well, first of all, it's okay in the foreclosure world for there to be some risk in this kind of transaction for the defendants, but in fact, the defendants own. There was conflicting evidence in terms of being sold together or separate, and the evidence was that the defendants themselves have been trying to sell it together as a unified parcel before this foreclosure action, and in fact there was some discussion of a settlement offer where they agreed to try and sell it together but split proceeds 50-50, which was not acceptable, and was not required to be accepted, despite the defendant's argument that it had to be accepted. But the defendant's own appraisers said that the plaintiff's appraiser said that there would be extra value in marketing together. The defendant's appraisers said something opposite, said that it wouldn't make a difference whether they were sold separately or together. And Judge Sicilian noted that difference between the defendant's own appraiser at trial and the defendant's own conduct in trying to sell them together, which is why at the end of the day, didn't give much credibility to the defendant's witnesses, and said that we're just going to let the defendants make that choice, and it's a legitimate choice. I'm not going to require one or the other. I mean, it's all to the benefit of the defendants, which we don't disagree with, because at the end of the day, our client will be made whole, even if it's a more cumbersome process than we had bargained for.
Thank you for your answer. I don't want to take up too much time in case my colleagues have questions or you have other points you wish to make. Thank you, counsel.
So, Your Honor, so at the end of the day, the defendants here want to create a bright line rule that simply doesn't exist. They want to ignore the definition of the premises. They want to ignore the bargain for remedies provision, saying that it can't even be taken into account, period. That's somehow against public policy. There's no case law that says that, none whatsoever. And that's why that at the end of the day, I think they fall back on, Mr. Fish didn't get to it, but perhaps he will in rebuttal. They fall back on a technical argument saying, well, set aside public policy, somehow there was a procedural default that prevented the trial court from reaching foreclosure by sale. But what did the trial court say in its decision? The trial court made a finding, quote, the record makes unmistakably clear that the plaintiff is seeking foreclosure by sale, and the defendants concede, as they must, that they were not surprised or prejudiced by the absence of a prayer for relief in the complaint or an a motion.
Counsel, Justice Ecker has a question.
Yes.
Yeah, thank you, Mr. Babin. And I'm aware of the procedural argument. I think the rest of the court is. I don't mean to cut you off on that one, but I do have a question that just occurred to me while as I was reading the briefs, and I can't get it out of my head. It's this. So we have two extremely talented, capable lawyers here who have devoted their resources to trying to figure this problem out. And I don't, correct me if I'm wrong, but I don't think anybody has cited any case anywhere in the United States that really takes on directly this issue. You know, I know there's Amoresco, it's a little off, and I'm sure you cite cases that aren't quite the same. That strikes me as bizarre that nobody has dealt with the couple of questions that this case presents. Could you either explain that or tell me why you think I'm wrong and there is an on-point case? I'm sure you guys have checked everything out and looked at every rock.
Yeah, well, it's a good question, Your Honor, and whether we had failed to do a scorched earth research or not, I can't say. We certainly looked at a lot of cases. We tended to look at Connecticut cases in this context. We thought that they were sufficient. Perhaps there's cases elsewhere that we just simply haven't uncovered for, and I apologize if they're out there and we didn't uncover them. I do know that this court in New England Savings v. Lopez was very clear that the courts do have discretion in terms of sale or foreclosure, even if the sale results in a deficiency judgment, in the wide equitable discretion where the court gets to decide whether it's strict foreclosure or for sale. Do I have a specific site that's exactly on all fours in this sense? Perhaps not. Perhaps when it sits in foreclosure court, most of the foreclosures do not like this case, and that's why I think the trial court here exercised appropriate discretion, had a trial, thought about the issues, and came up with an appropriate, equitable response. So just to sort of finish up, in case there's any question about the procedural aspects of this, I do just want to emphasize that with the trial court's finding that there was no surprise here, that even the defendants themselves in multiple filings agreed, even while the pleadings were open. In our Appellee's Appendix at page 10, defendants filed something that said the sole issue to be determined at trial is whether a judgment of strict foreclosure should be ordered or whether plaintiffs entitled to foreclosure by sale. And then on page 11 of our Appellee's Appendix, again in another pleading, the defendants agreed that all that remains for the court to decide is valuation and the type of foreclosure to be ordered. And when trial itself began, Mr. Fish stated to Judge Sicilian in the transcript on page 30 of our appellee's appendix that the defendant's counsel says that they're not going to make a huge deal out of the fact that the complaint only mentions strict foreclosure. They only made a huge deal out of it in their post-trial brief, which is really too late. But even then, in their post-trial brief, they make this technical argument after they saw how the trial went. They conceded that the issue was not a surprise. And that's why Judge Sicilian says that they have to concede that they were not surprised, that it was unmistakably clear on this record. And therefore, the fact that there wasn't a document that said motion for sale is just that it would have been redundant. It was clear as can be by all the filings in this case that was the issue, and that's why there was a trial and a decision. So the only other thing I'll mention, Your Honor, is that Mr. Fish mentions Article 9. That comes out of the blue, not in his brief, and it only refers to personal property. Article 9 has nothing to do with this case, and we were not given an opportunity to brief it. But that has nothing to do with Article 9 is personal property. So with that, Your Honor, we believe that judgment should be affirmed. Thank you, Your Honors.
Thank you. Attorney Fish.
Thank you, Your Honor. Justice Ecker, first to your last question. The reason I think we can't find cases on this are two. One, the parties here agreed on the appraisal price. That's unusual. Usually there's a dispute about the value of the property. Second, in my experience, when you have a fact situation like this, where the parcel is worth more than the debt and the owner, and there are no subsequent encumbrances, is not seeking a sale, a strict foreclosure is what happens. So the fact pattern that we have here is unique, both because of the agreement and because of Judge Sicilian's ruling. And that relates to Justice Dioria, your question about an example. If we change the facts slightly here and say we only have parcel A, so there's one parcel worth $950,000, one debt of $900,000. My advice to my client, because I agree with Justice Ecker, that it's very likely that a sale of 70% or even less will be approved by the court, and there will therefore be a deficiency if you do a foreclosure by sale. My advice to a debtor owner in that position would be, do not seek a sale. It is not likely that you will get equity. I know trial courts counsel individual debtors of this risk, because if you seek a sale, I'll give it to you, but if the sale price is less than the debt, you will have a deficiency. Newbar Realty Trust is not a single asset entity, and therefore it would be exposed to a deficiency. So if you factor in the remedy language, and you as a trial judge now have to say, okay, the owner is not moving for a sale. There's $50,000 of equity in this property, almost worth $1 million. Is it appropriate to order a sale, expose the defendant owner to the risk of a deficiency when we know under Connecticut strict foreclosure law, a strict foreclosure absolutely indisputably pays the plaintiff in full?
Thank you, counsel. There are a couple of questions. Justice Mullins.
Thank you, Justice Ravana. Good morning, Attorney Fish. I'm just trying to hone in on what exactly is the abuse of discretion by the trial court, and what I'm seeking, I guess, from you is it the case that you're saying it as a matter? It's really not a matter of discretion. It's as a matter of law. The court had to order a strict foreclosure, and if that's not the case, what was it that made this the abuse of discretion to order foreclosure by sale here?
The first error of law, which equates to abuse of discretion, is when the trial court considered the potential, as he put it, a shortfall based on post-strict foreclosure matters. The trial court said, if the plaintiff gets a strict foreclosure here, it has a risk of a shortfall, meaning it is not being paid in full. That's legally wrong because the 950 is bigger than the 900. And the risk of a shortfall came from such things as post strict foreclosure insurance payments. I'm going to have the plaintiff pay a broker to sell this property someday. What will the property sell for? There'll be taxes to be paid. All of those things that necessarily transpire post strict foreclosure, the court considered in exercising its discretion. That is wrong. Those things do not belong in the mix as a matter of law in Connecticut, because a strict foreclosure, unlike what the court said, could not legally result in a shortfall. So when it considered those matters, that is an abuse of its discretion because it's an error of law. Second, I think that error influenced the court. And the answer to Your Honor's question that was included is yes. When you have facts like this, where the value of the property is more than the debt, and the owner, again, no subsequent encumbrancer, and the owner is not seeking a sale to expose the owner to a deficiency. And to Justice Ecker's point, it's the risk of that. It's not my speculation as to what might happen. It's the risk of that. The risk of that to the debtor, that risk is unfair. And as this court has said, when the trial court is exercising its discretion, it is to do it with fairness to the mortgagee and the mortgagor, not just the mortgagee, which ties back to my Article 9 point. So the mortgagor is entitled to fairness here. Fairness requires a strict foreclosure of parcel A on these facts.
Forgive me, you may have started off your argument originally with 3 points, and these are 2 of them, right? And you may have another one. But before you go there, I just want to ask if it matters that the facts here, which kind of, we have this parcel B also. So does it matter that the court could be considering that, you know, if there's a sale of parcel A and there's a shortfall, you still have parcel B to sell, which would definitely cover whatever debt that there is. Does that matter to put that in the mix?
It does not, Your Honor, because when the court was talking about a shortfall, it was not talking about a shortfall in the context of a foreclosure by sale. It was talking about a shortfall if he granted a strict foreclosure of parcel A to the mortgagee. And the shortfall that the court is positing would have been to the mortgagee post strict foreclosure. So it's a different question. And my third error that I claim is by including the remedy section, the selection of remedy as part of the mix. That was inappropriate for the reasons I've already articulated. And I think the example I gave to Justice Dioria is very apt, because if you posit a simple case, again, with a $950,000 property and a $900,000 debt, the idea that the mortgagee can dictate or have some weight in front of the court by saying, we bargained for a foreclosure by sale, to me is absolutely wrong. They did that pre-default. They did that and it'll appear in many, many mortgages, and it impinges upon the discretion of the court. I would also note that Mr. Babin said that the plaintiff here did not consider a strict foreclosure. I find that to be inappropriate, not as his comment, but in terms of a factual statement, because the law in Connecticut is we are a title theory state. Strict foreclosure, as the appellate court has said more than 3 or 4 times, is the norm. And the idea that I didn't even contemplate the possibility of a strict foreclosure, it can't be the case, because it's contrary to the law of the state of Connecticut, and therefore the plaintiff is presumed to know that law, as we all know. I would leave the court again.
Counsel, there are still a couple of questions, and your time is almost up. The problem I'm having is that these are sophisticated commercial parties, and your client could have bargained for a marshaling of remedies provision in the document, in the mortgage, but it didn't. Why does your client get to marshal remedies now when it didn't bargain for that originally?
With all due respect, Justice McDonald, I don't think this would be a marshaling issue. Marshaling is when you have multiple subsequent encumbrances who are not on each parcel.
It can be, but not exclusively.
But but the bottom line, that my answer to Your Honor's question is that in this context, may I finish? I might see my time is up. In this context, the parties, let me start again, Your Honor. First of all, the remedy section is inartfully drafted, and I don't concede it says what plaintiff suggests it says. It talks about a power of sale, and as Toro states in its brief, it gave Toro the right to sell the property. So we don't have a power of sale in Connecticut, obviously. So the language, first of all, I don't think says what the plaintiff says it says. The second point is that in Connecticut, that provision should not override the discretion that the trial court has to select the remedy. It's a different issue. So if I go back to my point with Justice Dioria, if that mattered, then the mortgagee would be entitled to a strict foreclosure of a property that had significant equity when the owner was arguing it should be for sale. Flip it around, entitled to a sale, in my simple example, where there's only a little bit of equity, and now it's exposing the owner to a deficiency judgment. The trial court should not be dictated to by those provisions, and that's, again, consistent with my point about Article 9.
And I totally understood your argument about what potentially could happen with lowballing at a sale, but it is speculative. It's just as speculative as suggesting that if it went to sale, it would get $1.2 million and your client would get $250,000 back because of a hot real estate market. Why is that any less speculative?
I disagree, Your Honor. It is common the case that liquidation sales, foreclosure sales come in less than fair market value. So it's the risk of that.
I'm sorry, counsel, but this is 33 acres of undeveloped land. That's not your common foreclosure sale. This isn't a house in Waterbury that you're going to get some investor who's looking to buy and flip. That's not what this market is.
We don't know that, Your Honor, and I don't disagree with the court on that point, that it may be that the only one who shows up to bid is the plaintiff. My point is, when you looked at the two alternatives, A being strict foreclosure of parcel A, which again indisputably paid the plaintiff in full, versus B, which is the foreclosure by sale process with all the what ifs, whether the plaintiff is the only bidder, whether there's two bidders, whether it sells for $450, whether it sells for $600, there is a significant risk that it's going to take parcel A and parcel B to be sold in order to pay off the plaintiff, and that there will be a deficiency. That risk is my point. It's not the certainty of it, it's the risk of it measured against, or balanced against, better said, the certainty that the mortgagee would be paid in full in a strict foreclosure of parcel A.
Okay, thank you.
That's the,
Justice
I know I'm going over, Your Honor.
Justice Kahn has a question.
Thank you, Justice McDonald. I'll try to make this very quick, counsel, with no follow-up. I understand your argument that the court has to also consider the mortgagee's interests. And I want to take you back to the hypothetical or scenario that you used with Justice Doria, which was you only have one parcel, 950. It's appraised at 950. They're fully satisfied. But in this case, the mortgage was secured by two parcels, not just one. And what isn't really what you're saying is, look, we don't want to take the risk. We'll just say they're satisfied with the first parcel at 950. And now they're presumably going to sell it, right? They can't use it anyway. They'll have to go and sell it. So you're saying they can hang on to it or they can sell it themselves. And aren't they the ones that then incur the loss? So my point is the court's looking at a mortgage that's secured by two parcels. And yes, the appraised value on its face meets the debt. But it sounds like the court, if you're right, that if it was a foreclosure by sale, it would sell at a much lower value, then how are the mortgagor's interests protected when they secured a mortgage with two parcels, not one? If my question makes sense.
No, I think I understand it, Your Honor. Toro, as the mortgagee, is protected because they are fully satisfied as a matter of Connecticut law with a foreclosure of parcel A.
So
They're
as
not
a matter
entitled.
of law, but not practically. Is that the difference? Practically, they may not be, but as a matter of law, they are?
Practically, we don't know. I mean, yes, I guess is the answer to Your Honor's question, because as a matter of law, when they take title pursuant to a strict foreclosure of parcel A, they are fully satisfied. That is all they are entitled to as a matter of Connecticut law. If we open up the door, open up Pandora's box to look into the future, what will happen after a strict foreclosure? That is a giant door that trial courts are going to have to figure out. How do we deal with all these issues? So in my mind, they are in Connecticut. We are a title theory state. And when they're fully satisfied, that's all they're entitled to. This court has said that more than once.
Thank you, counsel.
Thank you very much, counsel. We appreciate your time today, and the court will stand in recess until our 11 o'clock case.
Thank you.